depositions, no one called anybody, okay? You waited until the day before the deposition, and at 2 or 3 o'clock, you sent an email saying, oh, first of all, Mr. Brown's got COVID, and then he's got bronchitis, and I don't know what the heck he got now, but, you know, he should probably donate his body to some medical school because he's had so many diseases.
I think he had hard drive document production and general document production. So you just,
Okay, so you'd like an update on the other 3 categories?
because then we'll have a hearing right after that. And looking at some of the issues that have been raised as of letters I was getting this morning, Jason Brown, that actually got worked out.
Well, maybe it got worked out. You know, I talked to counsel yesterday, and it's really the first time. But anyway, they explained some of the problems they had. And so I told them I would move Jason Brown back because the doctor's note, which was kind of a beautiful doctor's note, but leave that aside. Doctor's note says he's coming back to work on February 1st.
Yeah, I think I saw your letter that said you'd take it February 3.
We've noticed it for February 3. That's the date I gave them yesterday. You know, I haven't had any blowback on it. I told them I'd move it up if they wanted, you know.
Well, as of now, it's set for February 3. Who's here for Milwaukee Instruments?
Robbins, Floyd.
Rob, are you at all involved in scheduling that deposition?
No, the first, I think I just recently saw that it was going to be February 3rd, and I didn't have a problem with that because the doctor's note that we received.
You're going to have to speak up for the court reporter and your senior special master.
The doctor's note we have from him states that he's expected to be back to work or going to be cleared to go back to work after February 1st. So it's shortly after that, but assuming he is, or maybe he can even get back sooner, that should give me time to meet with him, prepare with him, and take the depo. We'd like to get that.
All right, well, he's set for February 3. What I was asking is, if you would you take the task of contacting your co-counsel and communicating with Mr. Kemp the status of this February 3? I don't want to get a letter at 2 o'clock on February 2 saying, oh, by the way, he can't be there tomorrow.
Yeah, I mean, listen, I know we've been going back and forth, but we've been attempting to contact Mr. Kemp and Mr. Pepperman. And, you know, I'm not exactly sure what the issues become, but it's not on my end. That's all I'm going to say. I've attempted to stay in contact with them and keep them informed as I'm able to get information from Mr. Brown and his doctors. I'm constantly trying to keep people informed on that. I did appreciate seeing it after we were able to get that letter, the notice being February 3rd. I think that's reasonable. I understand everybody wants to get these done. We do too. And I have every hope that we'll be able to go forward on February 3rd.
All right, well, I'm asking that you personally, even though that may not be your particular assignment, I'm asking that you look into that, follow up with it, and let Mr. Kemp's office know by e-serve letter. It's really the easiest, then we all see it.
Yep,
Yeah,
but
not a problem.
We have our motion for default still filed on Milwaukee, and otherwise I wouldn't address this, but he said that they were attempting to contact. And that's a position they've taken a lot of lawyers. Yesterday was the first phone call they ever made to our office, and the call came right through to me.
That's absolutely untrue.
That is
absolutely untrue.
And if you
I
look
called
at
Mr.
the honest letter,
Just a minute.
One of Pepperman, and I called you as well.
Kemp,
no one.
Rob,
Okay,
time out. Both of you.
regarding these.
Will. Let's let Mr. Kemp finish, and then Rob, you can go. But I'm not the one hearing the motion to strike the answer and enter a default, so it's kind of unnecessary here. You two can work that out with the court.
Regarding these depositions, no one called anybody, okay? You waited until the day before the deposition, and at 2 or 3 o'clock, you sent an email saying, oh, first of all, Mr. Brown's got COVID, and then he's got bronchitis, and I don't know what the heck he got now, but you know, he should probably donate his body to some medical school because he's
All
had so
right,
many
all right.
diseases.
I think he had, I don't think it said
Yeah, I
COVID.
guess it only
said
matters.
No,
when
no,
it's
they told us
sick, right?
COVID originally.
But the medical thing, document I saw said bronchitis, regardless of the cause.
Right.
All right, well, I'm assuming that's going to go forward on the 3rd. That's the way it's noticed. Keep Mr. Kemp's office notified by e-serve letters so the rest of us know what's going on.
Well, we still have the problem that you ordered them to produce all the other materials, starting with the insurance policies. To date, they have not produced any insurance policies 2016 to 2020. Okay, they haven't produced any of those, and we've sent letters. You ordered it; it just hasn't happened, and why that hasn't happened, I don't know. And then the second part is the parent company. What's the name of the parent company again? SDT or something?
SID.
Yeah, so both Han and Milwaukee are owned by a parent company, which is SID or something like that. Both defendants, we've asked them to produce the insurance of the parent company because Hannah at least produced the organizational chart, and basically it shows the parent company, this SID, and then it shows Hannah, Milwaukee, Pennsylvania. Literally, it shows 20 other boxes of companies. So the parent, you would think, at least in my experience, the parent has its own insurance because the parent is not listed as a named insured on the one Milwaukee policy produced, and the parent's not listed as named insured on the Hannah policy. So someone needs to contact the parents and say, where's your insurance policy? Because we've asked for it.
The attorneys for the litigants, that's the Milwaukee Instruments and Hannah, in this case, those counsel have a duty to contact the parent to investigate whether the parent has insurance that benefits their client. What is the status of the production of the Milwaukee Instrument policies?
Okay, so we've produced what I thought was the relevant policy, which was the 2020, I believe 2021 policy. We've also produced the name and address of our broker. Today, not only did this 2016-2019 not come up during our meet and confer, which was after the November 3rd special master hearing, this is the first I'm seeing it. I don't have a problem with that. We'll definitely produce that. I just have to get hold of the broker. I've already, looking at the agenda, I've already instructed my office to contact the broker and produce those policies that we have as well. Part of the problem I've had is with Jason Brown, he doesn't seem to know anything about SID. So I'm trying to work myself through the process of who the heck I get hold of at SID, or the SID International. So it's not somebody I represent. It's not anybody that I've had contact with. But Mr. Kemp, my understanding is he had a conversation with one of my associates yesterday and expressed his interest in that policy. So we are trying to work ourselves through that to see who we can find that can get us information on that. But according to Mr.
You don't
Brown,
have anything in
they have their
December.
own insurance.
Just a minute, we'll be here all day. You don't have anything on the 2016 to 2019 policies, right? But you're looking into that now?
I didn't produce that because I didn't think it was relevant. I thought this was a batch issue when I took over to this thing. That's the news reports that I saw featuring Mr. Kemp and Mr. Pepperman saying it was a batch problem. So those are the policies I produced.
All right, well, I need you to investigate that and let us know what's going on.
No, we'll have those maybe by tomorrow even. I mean, that's not an issue. I have access to that. So we have a broker. We're contacting the broker, and I've also given him my broker's information in case he wants to subpoena the records directly from the broker.
Yeah, the 2016-2019 was discussed at the meet and confer. It's part of the letter.
It was not.
It's part of the letter I wrote to you, and it was attached to the court order. Okay.
It was not discussed.
I don't need a debate. I need the policies.
That's not a problem. I've just said that's not a problem.
All right.
When is it not a problem? When are you going to?
Well, we're going to have a
told
hearing.
you, we just contacted. You'll have it by next week.
Including the parent policy.
No, I don't know. I don't have a contact for the parent company. I've got to sort myself out. That could be next week. I don't know. But I don't represent them.
All right, let's see what's produced within a week or so by Milwaukee Instruments. There was also a issue about, you said their discovery responses, other than the insurance. What else are we
Right.
talking
Okay,
about?
we asked them for any customer complaints. They produced, I don't know if it's 200 or 300 pages, but they did produce some Q&A from some sort of chat thing that they had, which was very helpful, actually. But in reviewing that, we find out that they also had a Q&A on Facebook Messenger, and they have not produced that. So I don't think there's been a complete production of the customer complaints. But I intend to explore that we have one, on Wednesday, we have a deposition set of one Hannah guy. And on Thursday, we have another Hannah guy, but that Hannah guy is also the president of Milwaukee. So I expect to flesh this out in those depositions, but I don't think there's been a complete production of the customer complaints
But
yet.
when it comes, the volume of this case, when it comes to stuff like that, just send Rob a letter as to what you think is missing.
Right. Well, we just got, last Friday, they produced.
No, I
the
understand.
Yeah.
Did we depose Brent Jones and is it Amy Jones? A-I-M-E-E Jones?
No. We deposed Wayne Jones.
Is he the owner?
No, Blaine was the 30B6 for the recipe of real water.
And that deposition's gone forward?
It has, and his personal deposition is now set February 23rd or something like that.
Is there a Brent Jones or was that a typo in
There's
the
a Brent
request I
Jones
got?
And an Amy Jones. Those two are not those two. Brent Jones is a named defendant in the King case, and he is personally declared bankruptcy.
Has the stay been lifted?
The stay has not been lifted.
And
I
who's,
would ask that they just dismiss him because there's no insurance other than the insurance that's defending him through the company. That he's been named by the plaintiffs and by one of the distributors, I don't remember who. And I don't understand the purpose of that. They might as well just dismiss him because any activities he did was in the course and scope. If they're going to go after him for personal liability because he signed a personal guarantee to a distributor, that's in the bankruptcy court. Go litigate that issue.
and is, I guess it's A-I-M-E-E, I'm assuming that's spelled correctly. Is
That's
she in the bankruptcy also?
He is also declared personal bankruptcy.
All right, well, for now,
Well,
they're stayed anyway.
I don't think they're state as to us because we haven't sued these people, okay? They were originally brought into litigation by the strip. And then I think they've been added in the King case, but that's
They
the
were
only
named-
case I know.
They were named in King originally, and then distributors named them, copying the,
Yeah, but I mean, we did some research and I shared it.
We sent a letter.
Yeah, we sent a letter with the research and the research says we can still take the deposition. We don't have a claim against him.
He's a witness. And
Yeah, he's.
Yeah, but, okay, let me just put it this way. When I started bankruptcy practice, it was with a guy they've named the federal building after. And to take a deposition of a debtor where you're asking them questions about pending lawsuits in which other parties are prosecuting them is probably a violation of the bankruptcy stay, or it's close enough, I'd get a lifting of the stay. So you're going to call them in and say, well, we don't represent the people suing you, but we're going to ask you about it. I think that I'm not the one going to me like that's within the scope of the stay. Aren't you worried about that?
in our short answer, I mean, is that a possibility? Yes. Are we worried about it? No. We offered in our letter to stipulate to exclude any type of questions that may encroach upon a bankruptcy issue or implicate the personal bankruptcy estates. We just want to ask him purely fact questions about real water and his role in it as a operator and owner of real water. So, I mean, we just don't want the delay. if there's an effort or some, desire to get a stip to avoid something like this, we'll do that. As long as it's not saying, oh, we want this 3-month process so we can put off their depositions for 3 months.
Well,
Because
are you going to serve them a subpoena for the deposition?
we can. I mean,
Well, I think you're going to have to. Nobody here represents them, do they?
Not exactly. Brent Jones is a defendant in the King case, the King plaintiff.
Lisa King?
Yes, she has personally named him. He is also a third-party defendant in a bunch of other cases.
Are you defending him in the
I am
Lisa
defending
King?
him in the King case, yes.
Well, why don't you investigate so that we don't have a problem later? Why don't you investigate whether we can go ahead and take his deposition, or you or his bankruptcy attorney is going to take the position we need to stay lifted?
So here's what happened on that. They sent me a stipulation and asked me to confirm that he has other insurance to cover this claim, which he does not.
Who sent you a stipulation?
Plaintiff King, the King plaintiff sent me
I
that.
didn't, can I just interject? Danielle Miller for plaintiff Lisa King. I didn't send a stipulation. I asked if they would confirm whether he has any insurance that would cover this and whether they would stipulate to lift the stay.
The stipulation on the stay wouldn't come from me, and I don't have an objection to it at all. He does not have any other insurance to cover it other than the insurance that I'm defending him through as an officer of the corporation. And if she needs my help to talk to the bankruptcy attorney, I've already volunteered that, but it has to come from the bankruptcy attorney to lift the stay.
And
It's
Danielle Miller
necessary.
again, I've reached out to the bankruptcy attorney. I'm waiting to hear back from her. I sent her an email yesterday on this.
Yesterday.
Yeah,
Uh-huh.
I was
Well,
like,
the
why
bank-
just dismiss
I-
him? What do we need to have his personal liability? It's a dry hole. I don't understand the.
Well,
the
that's not for me to
strategy
decide, but for the deposition, I appreciate the fact that you've contacted the debtor's attorney. So, well, at least they're on notice. So I'm assuming that'll get taken care of that way.
Yeah, and I'm not objecting to the stay being lifted. I just don't want to get crossways either.
Okay.
well, I think the purpose of putting it on the agenda was we were working out, scheduling these 2 depositions.
That's
and
what
then-
I'm trying to do now.
And then when we were just waiting for dates, we got this letter saying, oh, they filed for bankruptcy, so their depositions are stayed. Is that the position that they're taking, that the stay needs to be lifted? And if so,
You heard the same thing I did. She just reached out to the bankruptcy attorney for the debtor and asked. She hadn't gotten a response yet.
But
Well-
Floyd, Danielle Miller again for Lisa King, it wasn't in relation to the deposition. I didn't discuss that with her. I think there's 2 separate issues here.
yeah, we haven't sued him. We don't want his personal assets or worry about any other insurance. We just want to take his deposition as a fact witness in a timely manner.
But he's been sued in related cases, and it could prejudice him in those related cases, and that's what the stay is all about. It's extremely broad. I'm not saying that the debtor's attorney wouldn't agree to waive it or anything else. It just so they're notified. I mean, you can take the deposition. I'm not going to enforce the bankruptcy stay, but I'm concerned about it.
No, and I understand and I appreciate that. I guess it is the position from Brent Jones as his attorney that he's not going to provide a date unless the bankruptcy stay is lifted? Or is there some alternative?
They don't know that it's necessary. They're trying to find out through the debtor's attorney, right?
Yeah, and
Is
I
that
agree
this,
with that,
is
but
it
there's
this,
another issue here is that this deposition is going to go more than 7 hours. I already anticipate there's a request because Brent Jones, from my understanding, was involved in the marketing of the company and all sorts of other issues. I'd be thrilled if we want to agree that it's only going to be 7 hours, but I doubt that people are going to agree to that. So it's going to be more than 1 session. And I think it's only fair that there's a discussion with his bankruptcy counsel. Here is the plan. And again, get them to lift the stay. And then this is all non-issue.
Why don't
is
you,
his bankruptcy counsel the same as Real Water's different bankruptcy?
Now, it's a different attorney. She's in Texas, and I don't know her personally.
didn't Danielle,
Floyd, her name, Danielle Miller again, her name is Liza Green. And I have her email address here. I can forward it along to you and Eric.
All right, do that. And just, why don't you just set the depot and give them notice you're doing it? I wouldn't worry about asking for permission first, and then just set the depot and give them sufficient notice to see if there's an objection.
Okay. I think we skipped one, which is our money.
I was kind of going through mine, but yeah. And I'm sorry, I didn't have it on my list.
Okay, we always have.
Well, let me
our list.
finish this other.
Okay.
I didn't quite follow. You said you wanted a status of CMO and discovery dates for judge status hearing. I didn't go back and list all the ones she had. So what's the status of, what's your request on that? What discovery are you missing?
So we had a status check in front of Judge Alf on all the cases in front of her, and she asked us to meet and confer on a discovery schedule.
Does she have the 9 that I was ordered to coordinate? Isn't she the one that issued the initial order?
She's the lead
for me?
judge.
So it's Wren and the other 8 that were in that initial list of 9.
No, she has Wren, Sharapov, Martinez, and one more.
Okay, go ahead.
Of ours, at least. We just hadn't touched base on this, so I wanted to put it on.
No, that's fine.
Here.
Yeah, I have something to add on this. It kind of goes hand in hand. I was in front of Judge Kishner on the Gielman case, and that case is going to be coordinated. But Judge Kishner advised that she has returned her CMOs to you, Floyd, and the ball is in your court. So I want to, we need to get the CMOs done
I've
in
communicated.
one of the cases so we can use them in the others.
No, 2 meetings ago this came up, and I informed her JA, said, I didn't prepare them and I didn't send them to you. And if you rejected them because of dates, what dates do you need?
I was in front of her
And
for-
I don't know if I asked you to call her JEA to see, could you get an answer from the JEA?
It wasn't specific, but she did say this is the general timeframes, and we amended it and then resubmitted it. And
Which is what I asked them to do, Joel. I asked them
Yeah.
to communicate directly because they drafted the CMOs, which I had approved.
I ran it by.
Yeah, and we're
Yeah, no, I know you
talking
did.
about- What I'm saying is I was in front of her a few days ago and she thinks the ball is in your court, Floyd. So
That's
we could,
fortuitous.
I figured I would raise it today, we can all get on the same page and get it done.
She signed it?
So, Floyd, have you only submitted them that one time?
Yes,
Okay, so
I think. I don't
Maybe she wants-
I didn't know it was an issue.
I believe we submitted them to you for signature to submit to her. So
Well, then
that may be where there was a disconnect.
No, I would have submitted. I'll look into that and let you know directly.
Floyd, could you send them again to Judge Kishner and maybe she'll bless them and we can move forward?
Judge
on it?
Master, Hale, this is Brianna Switzler from the Kemp Jones office. We contacted your assistant, I believe Debbie, yesterday just to see if we can get a clarification on this. She said that she had submitted them a second time to Judge Kishner. So I don't know the time frame of that, but we reached out to her to try to make sure we could clarify this issue. And she represented, I think, that she had already submitted the CMOs for a second time to Judge Kishner. I believe that was
Yep,
yesterday.
Thank you. That's what I remembered because I'd asked her to do it, but I didn't ask her before this hearing if she had actually submitted them, and I didn't look into it. So what we'll do, I guess I'll contact her department and ask what the status is.
Yeah, I mean, she
I'll do
represented
that.
to me on January 10th that it had gone back to you. And so I think if you want to represent that I informed all parties that on January 10th, I was told that you have them and we can go from there
Because I do remember she sent them back at one time and with an email. And I said, what dates? The dates aren't right. Oh, okay.
Yeah.
What do you want? And I haven't gotten a
her
response.
staff told me it was the court dates And it sounded like the motion and limine dates
Yeah.
were the ones that are at issue.
And I informed her, I don't normally in calendar or schedule the motions in limine. I usually let the courts do it because they have to read the briefs and rule on it.
And
All right, I'll look into it
by
again.
Statute, so maybe if you push them back 2 weeks or something, or maybe you
Well,
already did.
It
Yeah.
was 45, I thought we pushed them to 60.
So we've amended them based on what, so you're right. We submitted them to you. You submitted, signed off, submitted them to Judge Kishner. She kicked them back because the dates were off. We discussed it. We were asked to contact and see what dates would be acceptable. We did that. They gave us some ranges. We complied with what they said,
Sent 'em-
amended them, and then sent them back to you.
And I sent them to Judge Kishner.
Yeah,
I
so
just didn't know the date.
It's probably after the 10th because this was all kind of right around the holidays time. So, and I know you were out for a while, so it might
Me?
have been.
I wouldn't know. I'm here every day.
I thought at the beginning of the year there was some time where.
They don't
Oh, so
give
I
me
didn't
any
mention
time
that.
off. Haven't been.
Oh.
Did I want to go to Mexico for Christmas?
Frivolous
Yes.
rumors.
Yeah. Do I have a condo there I haven't seen in 2 years? Yes.
Either way, I think the current dates, unless she's rejected them a second time, are
I will check.
acceptable. It's just a transit issue.
I'll take the rowing oar at this point to find out what date I sent them back over there. And
Then
I'll
we can
call the
adopt them
department.
To the other cases, that'd be fine. Then we can adopt them to the Judge Alf cases.
Well, you know, the motion, I agree with that, except I've never been able to control motions and limited deadlines, which makes sense. But I would submit the identical ones to Judge Al. She probably would.
Yeah, Judge Alf has asked us to provide a discovery cutoff, and then her court will work backwards to fill in the dates from there.
Okay. Well, I need proposals on discovery cutoffs on Judge Alf's cases. I think we've tried to do this every meeting, but we don't have enough. I don't think the plaintiffs have enough information, right? You're worried about going to trial missing people, aren't you?
I mean, at this point, we're, stacked up on dates, so.
Yeah, the way it looks now is we'll have Judge Williams, there's a little bit of an opening, and then we have Judge Kishner for trials in 2024. And I think Judge Alf was going to put him in 2025.
She said, submit the discovery cutoff date or schedule, and she'll set the trial based on that. So
you have Judge Alf cases. Who else has Judge Alf cases?
The carrier plaintiffs.
Carrier, that's the fourth one.
Any other plaintiff attorney?
Yeah, this is Matt Minucci for Adar, Borla, and Britton. We have Judge Alf as well.
Yeah. I'm sorry, for whom?
Adar, Borla, and Britton.
All right. Let's try to cut through it right now. What's the cutoff date you two groups would suggest for the Judge Alf cases?
We were thinking of
discovery.
just doing them in 2025, and so we weren't really worried about the discovery cutoff because
But I thought she wants to know by the February 8th status.
She does. I would suggest we just submit, we exchange a letter in those cases and agree to it. I don't think it's a problem. I think it's just making sure they fit within the,
Okay, then you two can advise her during the status.
yeah, I'm happy to do that.
I mean, if you two agree, I agree. All right. What's the status of the plaintiff's discovery?
Floyd, this is Jim Neale. I'd like to address it if I can, please.
so
This is discovery served on the plaintiffs, Floyd? Is that what you're?
No, the automatic discovery, the information sheets, the fact sheet.
Oh, I'm sorry. Thank you.
this is really a different issue. The fact sheets, I mean, I think they have some complaints about, but the issue as we see it now, is they want to go beyond what we thought.
And I got the targeted interrogatory letters, but
Okay.
what is the status of, generally the status of the fact sheets being produced?
So we produced the Henry fact sheet last night. And we've produced every other fact sheet for every one of our other clients, except for a dear Ita, who, as I mentioned at the last status special master hearing, has passed away. We are taking the steps to substitute his estate and the administrator of his estate.
Didn't someone already file a suggestion? A suggestion of death. I don't know if you're aware of it, but when somebody passes away, only a lawyer could draft this. The notice to inform the court that your client has died is a suggestion of death. I mean, the only two definite things are taxes and death. And in our system, it's a suggestion of death. But who are you going to appoint an administrator or administratrix?
Yes, his brother will be the administrator.
Oh, okay.
We are going to do our best to work with him to get as much information as we can. And he doesn't have the authority to sign it on his behalf until we get the order appointing him. So that's the only holdup on any of the fact sheets.
Oh, so you didn't get it? You didn't get the information from the decedent at all?
We gathered some information initially, but when we went to reach out to him to, fill out the rest of the fact sheet and get his signature and review, that's when we discovered he had passed away.
Joel, do you have the data on which plaintiffs are missing fact sheets?
I don't have it at my fingertips.
No, I don't mean now. I need either the claimants, the plaintiffs, to send me letters telling me the status of all their fact sheets, or I need Infinity or someone else to say, here are the ones we haven't seen. I don't care how we get that, but we need to update that.
Okay. Yeah, I can put that, I'll add that to our list. I know there's issues with the answers to the fact sheets, but that's a different question.
Right. As far as the dispute that was submitted on the, I didn't get the interrogatories, but on the targeted interrogatories following receipt of a fact sheet, you're going to have to go through a good faith effort to resolve that case by case, and then you're going to have to submit, both sides, submit individual, and when I say briefs, as you know, letters would be enough, and I will do individual conferences by phone and or Zoom with those attorneys.
So, understood, Floyd. This is Jim Neale. We've had that meeting confer with Mr. Pepperman on the two plaintiffs in Gallagher. If we could, we'd like to get a response to the letter we filed with you yesterday. That trial is coming up in a few months and expert deadlines are in March.
My initial information is yes, if it's truly targeted and it goes beyond the information in the fact sheet, it's discoverable.
Thank you.
I didn't get I got the letter. I got a couple of letters dated yesterday, and I got a letter the 19th and a couple of the 18th. I did not get, or at least I didn't print when I pulled up all the service in this case, the actual interrogatories in dispute. So yeah, I just want to look at the interrogatories in dispute if you can't resolve it.
I don't think targeted is the right word, because what they did is they basically served their own fact sheet, overlaps the existing fact sheet.
Well, I'll rule on. I do know this. There was something about. I thought there was something about her being a social media promoter, and they wanted information on her income or something. But I don't have the interrogatories.
All right, Floyd, we'll get you the interrogatories. And if the answer is to refer to the information that's in the fact sheet, that's fine. But
why do we have to do that? Why do you get to repeat the fact sheet?
Excuse me.
You don't. I'm just saying, serve the interrogatories. They object based on the existence of a fact sheet. submit the issue to me. I'll look at the
All right.
opposition and I'll rule on it, but I need the interrogatories that are in dispute or the requests for documents that are in dispute.
Okay, Floyd, understood. We'll get that to you right away.
Kind of inclined not to have a hearing on it, but if I look at it and I think it might be worthwhile, I'll do a phone conference with just the parties involved.
Thank you.
But there are too many lawyers and too many people involved in this litigation. Just say, okay, this is the rule. You're going to have to do a specific motion following a good faith meeting with the attachments, and I'll allow a response.
Understood.
Floyd, the only problem with that is,
Kind of ruled.
well, what's going to happen is I'm going to get 1 million written discovery requests from every one of these defendants, and I'm not going to.
Well, they might want to wait to see if they're going to get any result. I'm going to
Even
look through.
objecting and answering all this stuff.
What do you want me to do? I've only done this 47 years, so I'm going to rely on you since I've said I need the dispute in writing.
we'll
I
send
need an
that to you.
opposition in writing, and I need the documents in writing. What do you want me to do?
No, we'll
Fair
do
enough.
it.
I mean, if you get 50 of them, we're going to ignore 49 of them and decide it based on the first one.
Yeah, I just think, we're agreeable to targeted specific questions that weren't asked that couldn't anticipate. We're not trying to hide stuff because.
Did we cover income? I don't remember that. in
Yeah,
the fact
income was
sheet.
in the fact sheet.
Okay. I just, that caught me off guard. I didn't go back and pull that one. So we're going to do it through standard motion practice, although for those of you that haven't had the experience working with me before, when I say motion practice, just all you have to do is send me a letter, but spell out what you need and why in the letter. And it's always easier if you say, please consider this letter a motion to compel responses. It doesn't have to be a formal pleading brief and that type of thing, just something of substance that I can go through and the other side can respond to. Is there more than one of those? I thought I had two at issue right now
To what?
of the interrogatory versus fact sheet dispute. Are there just two groups that have raised the issue right now?
To defendants, you mean?
Yes.
I received 2 sets of written discovery requests. It's a very serious procedure.
I can't hear.
Hey, Colt, I think there's some feedback at your end.
All right, go ahead.
Yeah.
I received 2 sets of written discovery requests related to 2 of the plaintiffs in the Gallagher case, Belsky and Haley. I've received several letters from or requests to meet and confer on certain deficiencies in the fact sheet.
That's a different issue.
Which
I'll
is
worry
different.
I'll worry about that when it
And then
comes up on
some
each fact sheet.
Demands to just voluntarily disclose stuff as a required 16.1 disclosure.
All right.
Those are the issues.
All right, so I'll wait to see, because, and I'm assuming you two can work this out. The interrogatories, in addition to the fact sheets, would have to be pretty specific and stuff that isn't obvious from the fact sheet or issues opened by the fact sheet. Let me jump to you. Joel, do you have any issues?
Yeah, I joined some of the objections that Cole had made, just to keep it simple, when getting, letters. And I worked with Cole and came up with a list of issues that we both had.
On fact sheets?
Yeah, so my issues
No,
are the
that's
same
fine.
as Cole's, but it was easier to do it that way.
No, that's fine. Does anyone else have an issue you need to cover today?
Yes. Will is asking about the money,
Right.
Oh, I'm sorry, I forgot.
and that has been submitted to the carrier. And I'll follow up and find out what the check is.
For those of you who may have missed that, Mr. Kemp's office has been making the rent payments. Well, actually, it was on both, and now it's just Henderson, right? And The status of the Henderson facility payments, $44,803 as of January 1/23, and proof of insurance. And my inclination is to pick a date 45, 60 days down the road and let the facility go. When was the defense inspection and picking up the property and going to the warehouse?
So we got some apples and oranges here. Let's stick with the facility for a minute. We've been, by agreement, splitting the rent on the facility, and my carrier owes approximately $40,000 on the split.
To
So
Mr. Kemp's office.
so
Yeah, I
it's
do
not just
remember
their
that,
office paying 100%. We're splitting it.
but not paying it.
No, they pay it first because they had to sign the lease.
Right.
And then they ask us for reimbursement, and we're $44,000 behind on the reimbursement. And I'm following up on that check. As far as letting the facility go in June, that was my request, not their request. It doesn't really matter.
No, I know.
But
Yeah.
I don't know if June is going to work. I think that was just a suggestion.
All right, let's cover that at the next hearing, because we do need a cutoff. Everybody's been there, we've removed everything, right?
Well,
that we needed?
that's the problem. If you had a new defendant, then they're going to yell and
Yeah.
scream,
Or you-
we didn't get to see it.
Spoliation, yeah.
Not everything's been removed. The pumps that were at issue in the bad batch, or the pump that was at issue in the bad batch, is still there. There's still some meters there. There's physical evidence there that has not been removed.
Okay.
So, and everything that the plaintiffs took from from Mesa that has not gone to Hollow is still there. There's a lot of stuff.
Oh, we got moved from Mesa to Henderson?
It did.
Oh, that was good.
There's a lot of stuff there.
So now I have more stuff at Henderson than I
These
had
are
before.
items the plaintiffs wanted saved. And
Sure.
I don't want to throw away their stuff.
Yeah, I think given the amount that the rent is, assuming we can get reimbursed, I would kind of err on the side of as opposed to shorter, cutting off the lease. So I'm June, we talked about the
Why
reason.
don't you two work, and then if you two have an agreement to cut it off in June.
Yeah.
And we'll give everybody notice,
Right.
the earliest we can. I'm gonna probably 99%, I think I would just agree with you two on that. If we give everyone else adequate notice to tiptoe through the building and see if they want anything or want to look at anything.
And that's fine. We just haven't had a chance to talk
Okay.
about that part of it.
And then, there's other options. I mean, we could split the rent 10 ways if people want to.
We may as well cut it off. I mean, there's no reason to just,
Okay, we'll revisit the cleaning out of Henderson, whatever we want to call
we
it.
split it 10 ways, I'll be dealing with 9 issues.
You're going to get a check.
Those will be easy ones.
$57. Somebody. The insurance issue. Plaintiffs' counsel sent us a letter asking if, and I'm going to change their wording, there are gaps in insurance, and there are gaps in insurance. Every policy that we are aware of has been produced. My client's insurance carrier has a vested interest in finding more insurance, hopefully somebody to foot the bill for the rent as an example. And so I would anticipate that we may end up taking depositions of insurance brokers. We were hoping to find evidence of brokers in the
Right.
QuickBooks files, and so far we have not found them, but there are definitely gaps in insurance, and Real Water was not insured through Liberty Mutual in those gaps because we have checked. In addition, an
I thought
entity
the
called-
gaps were just like a 4-month here and a 6-month there
No, there's some significant gaps. There's at least a year.
for the relevant time period. For like
2016,
16 to 21.
there's a two. They were not insured through Liberty Mutual. In addition, the entity known as Real Water Gold Coast doesn't appear to have any insurance, and that's odd. So that we think there may be another carrier that we are endeavoring to find. But Eric or Will's letter to me was accurate in terms of the gaps. Those gaps do exist.
Let me go through my notes for 1 second.
No, it's not a real water, so. Continuing chips. Yeah. Status of that.
Oh. your out-of-state counsel issue.
Yeah, so
So,
I
yeah,
spoke
okay.
to some of the other third-party defendants, and they would like to submit an order with some different language, and I have no problem with their submission, but I want to get it squared away.
And for those of you, the way I would describe the issue is when you have out-of-state counsel admitted for any proceeding or deposition, the lead Nevada counsel has to be present, unless waived by the court. And what Mr. Odou is requesting is that anybody in his firm.
That's what I've requested. Some of the other parties have requested that the Nevada counsel be excused. I have no objection to that, but I don't know how different judges.
Having
will rule
served
that.
on the bar examiners for 22 years, the odds of the state bar approving that are slim and none. And they have the same chairman as they had when I started. And I quit in 94 and he's still, in 14 and he's still there and he's an ex-Marine. So what do you think he's going to do?
Who's the
Well, since
chairman
you
now?
graded my bar exam, I guess I better
I
defer
did.
to you.
Yeah.
Chairman?
Floyd, just to,
Check from
I just want to clarify. So Rule 42 says local Nevada council must need only be present in matters in open court. So are you now ordering that?
No.
It doesn't say.
What it, like the letter said, first of all, this is like a court proceeding. And I don't know, it doesn't just say matters of court.
The rule
But-
explicitly says open court.
Yeah, open court. But I don't have an objection to it one way or the other. I just have slim and no authority in this issue. But I didn't think there was an issue if it's Joel's firm. I think the firm is lead counsel down.
When I sign the affidavit
Right.
for admission, it
Rule
says
42.
I am responsible for the conduct of the out-of-state attorneys, and I have no problem with that. I just want to make sure there's no objection that if I can't attend a deposition and I have another Nevada lawyer at my firm.
It still
attend the
leaves you
deposition.
responsible.
I'm
I've
still
never seen that
responsible.
issue come up.
I'm just saying, I've seen somebody file a motion to strike saying, oh, Mr. Odou is the person who has to be here. He can't have Janice Michaels.
Let's test it in
attend
this case.
Wait a second. Hold
Let's
on.
test it. Let's see if someone objects. and
Wait a
then
second.
come-
But you're-
Wait a second.
Let's see what Tim's got to say. He's probably got.
Wait a second. Floyd. Floyd, can you hear
I'm
me?
listening.
Yeah, Rule 42 says, in addition to what was said earlier, it says all actions or proceedings pending before a court in this state. So it's not just open court.
No, I know. No, I think it includes any court proceeding, and that includes the depositions. And in fact, the state bar takes the position, you can't negotiate a case or arbitrate a case if you're an out-of-state attorney representing a third party.
And I agree
So-
with the arbitration one I had to deal with because an out-of-state lawyer out of Colorado attempted to participate in an arbitration case, and I called the state bar and they made us stop proceedings until their local counsel got there. So,
No, I think local counsel would have to be here, would have to be at the deposition. Any activity that's a formal activity in this case, which would include depositions and special master hearings and obviously court hearings, the local counsel, but I've never heard anybody contest the fact that it has to be Joel Odou as opposed to somebody from his firm.
yeah, and I'm not questioning that either.
And I appreciate that clarification on the record. As I said, I had a case where.
I'm not sure what my authority is, but I'll say it.
It's otherwise agreed to by. the
Certainly not
court.
even persuasive, I don't think.
Well, under Rule 42, it also can be a stipulation of the parties, an agreement of the parties.
We'll never get a stipulation. Does it say, what's the language for lead counsel? I
The
don't,
Nevada attorney of record shall be present in all
but
motions.
Smith is the attorney of record.
That's right. That's how I interpret that.
Oh, that,
I worry that
we'll
it's,
see if somebody objects. You can indicate at a hearing, you asked me and I agreed with you.
Okay.
And if somebody objects during a depo, we'll consider it at that time.
Well, so Section B of that rule says they shall be present in all motions, pretrials, or any matters in open court unless otherwise ordered by the court. So are you ordering local counsel to be present in all depositions? Because Section B is clear that It only applies to open court.
That's not exclusive. I mean, A starts out any proceeding. So, I mean, you're reading it just B, it's not. But, no, I agree with Joel's proposal. I think it's a good, you know.
Well, Section A says that the attorney of record shall be responsible for and actively participate in the representation of a client in any proceeding.
Well, deposition's a proceeding.
Yeah, any legal proceeding.
My interpretation is any proceeding includes depositions and would have even included the Mesa inspection and the Henderson inspection. But I interpret that the lead counsel is the law firm.
On another topic, going back actually a little bit, Floyd.
Can we hang on a minute? We're going to try to turn that up.
Okay.
Don't cut Mr. Parker.
I'll probably hang up on Teddy.
All right.
It goes, Teddy.
Try it again.
Okay, yeah, the only thing I want to follow up on, and Joel, when you're looking for the insurance policies and those gaps, make sure you're also looking for the excess policies as well for those primary years, okay?
Yes, and we have already done that exercise, and there are years with no excess and there are gaps as well.
Is there one broker for all these policies?
No, and there were multiple owners of Real Water going back to pre-2016, but there's a potential, there's other insurance out there, and we just haven't found it yet.
And this is one of the reasons we want to do Brent Jones's deposition, because every time we ask Blaine Jones a question in this area, he said, you got to talk to Brent.
So we take Brent about the insurance, but
Well, he knows about the other entities, the called co-ops or whatever.
Co-packers.
Co-packers.
Well, I'm assuming we're going to take Brent's deposition. Right.
You know, on the issue of co-packers, I'm assuming that there's been some inquiry made to them, like Real Water Tennessee, Real Water whatever. It's whether they have policies that cover.
Real Water Tennessee's policies have been produced, and counsel for Real Water Tennessee's online. That's why they're separate counsel. They were insured with
Hartford.
Hartford, thank you.
How many other co-packers are there?
Co-packer.
Or what's the word?
That's the word
Co-packers, yeah.
that FDA used.
Co-packers? for the
Other
men?
bottling facilities.
Oh,
They would send the concentrate to other
Yeah.
bottling, yeah.
It depends when. Like in 2014 or something, there was another one. There was one on the East Coast.
How about 2021?
There are no co-packers for Nevada.
Okay.
For sure.
But
Silver Springs was a co-packer, was the only known co-packer in Nevada that I'm aware of.
okay, well, let's use Utah for an example. So if the Utah product was sold, assuming it
I
was.
don't have information on Utah.
Okay, but I mean, let's just use this for example. So the Utah, we'll call it I'll call it a co-packer.
Sure.
So the Utah co-packer sells in 2021, but they don't sell to any plaintiffs, right? Probably not. But they do include Real Water Nevada as their named insured. The named insured? Is it named insured? Would they not?
I don't know about that hypothetical. We produce the entire policies. So if there are.
You produced the policies from Utah?
No, we produce all the policies I'm aware of. If there's a policy from Utah you're aware of, I will be happy to go find it and get it. I'm unaware of any policies for Utah.
When you had the co-packers, didn't you require that they provide proof of insurance to you? Because you were providing
I'm unaware
them.
of a co-packer in Utah, so you were just using this as a hypothetical.
Okay, yeah.
We have looked for any insurance, period, whether it's for a co-packer, whether it's for Real Water Gold Coast, Real Water Tennessee, Real Water US LLC, that's an entity we found no insurance for as well. We have looked for any insurance, period.
well, one of the searches of QuickBooks should be the word insurance, because it would be a write-off, it would be a business expense.
And I was disappointed in what it turned up. It did not turn up a business expense.
Oh, you did search that.
It turned up workers' comp insurance. But again, I spent 5 minutes with QuickBooks, so maybe smarter people than me will find it.
All right, anything else?
One last thing on
Go ahead.
on the proof of insurance. I was referencing the letter from the landlord, or an email from the landlord saying, because we had, if you recall, when we took over the lease, we had to provide a proof of insurance coverage, and Liberty Mutual provided it, and they asked for, I forget her name, Jackie something. She asked for a copy to ensure that the landlord is still named on there.
Follow up on that. Okay, I found her email. I'll follow up on that too.
All right, thanks. That's it for me.
All right, hold on. I'm just almost through my stack. We've covered all the issues, I think, yeah, but let me double check some. And I was going back also to our December 14 agenda, but I think we've covered it. Is there anything else any of council here would like to raise? All right.
Just as an informational thing, we served the Shaney Castile deposition. If you remember, we had it all set up last time, and she had an unfortunate run-in with the law, I guess, that when the defendants found out about it, notified us of, and she was, I guess she was at the time of the deposition. So
we have media listening.
Oh, well, okay. She was unavailable at the time of the
Thank you.
deposition. So we have rescheduled the deposition for Monday. And when we served the process on her, and she told the process server that she was anticipating having to redo the deposition because she had previously been unavailable. So I'm anticipating that she will actually be there on Monday.
Right, thank you.
I think it's set for 1 o'clock Monday.
All right, did you have any questions?
I do not.
You do?
I do not.
I was asking the court reporter.
You know,
I went above your authority. I'm
Yeah,
the court
exactly. She's more
reporter.
important than us, so.
Did you have any questions on names
No,
or
just what
anything?
Teddy was reading off of. Where it was
Of
reading
course,
from.
the only question she had is regarding you, Mr. Parker. What were you reading?
I just reading from the Supreme Court rule, Rule 42.
Oh, you're reading 42?
Rule 42,
Yeah,
okay.
Supreme Court Rule 42. I referenced the same thing.
And then,
Robbins.
Rob, the left, Rob.
Rob Robbins.
Sorry.
That's yours.
Okay, that was it.
No, you're fine.
Shoulder.
I would minimize it if I thought there was something obsolete about Rule 42.
We're done?
What's your name? Laureen. Frister.
You know, they take
Ariana Reed, Ariana Reed,
state attorneys and
Campbell and Williams.
adjusters come